Welcome to Employee Termination Tips. My name is Christopher Neufeld of Neufeld Legal. And if there are impending layoffs, terminations, or potential for being fired from your job, don't expect your boss to be altogether helpful with developing your case and determining whether or not your termination severance package is appropriate. They're not going to make it easily accessible to gain access to your employment materials. Typically, what they do is they shut down your cell phone service, they shut down your access to your emails, and oftentimes they do that as you are in the process of being terminated. And they don't really give you much in the way of materials that you might have at your desk, even though those materials are important to your making the appropriate determination as to whether or not you should be taking the termination and severance pay package that they are offering up. And you would say, well, don't they have an obligation to do so? Isn't this the material that I need? It may well be the material that you need, but if you don't have it in advance, and that's why we talk about the importance of retaining and preserving employment records of yourself, because they're personal to you and you got to be doing that. You should really be doing it on a continuing basis and having them offsite because they're your personal records. But if you see this coming about, you should be shifting them offsite so you have access to them because they're not proprietary to the company. They are your records. But why I talk about this lack of assistance and lack of help, and yes, some employers and the HR staff do provide you information that you request. There's a lot of stuff that they're not willing to easily give up to yourself. And as a lawyer, I know this all too well because here in the province of Alberta, we actually have employment standards legislation which sets forth requirements that go beyond the basic information and makes it an obligation on the part of the employer to provide specific information that will be extremely helpful to the employee once they're terminated and their lawyer to assessing and determining their status relative to the termination severance pay package being offered up. But even though it's an obligatory requirement for the employer to provide this stuff in Alberta, upon the request of the employee or the employee's attorney, what do we find? Well, it's not as simple as that. They realize, it seems to be at least, that this material is potentially very problematic for them. And it will disclose a lot of information that they don't necessarily want to disclose and disclose problems that as soon as they take a look at it, they say, there might be an issue with releasing this type of information. Even though the law says in statute that upon request, you're supposed to divulge it to the employee. But instead, they hem and they haw and they hold off on it. They expect you to go to court, take it to the Employment Standards Office, which is by itself a very problematic issue, which I'll address in another video. But they don't readily give you the information that they're legally obligated by statute to provide. It's right there in the Alberta Employment Standards Code. And if it's something that's required by law, and there's no real exemption from it, the employer could get penalized for it, but what's that going to do good for you if they get penalized for not providing you a document in a timely fashion in a year's time? In truth, it shows how reluctant employers truly are to provide information to their former employees. And if that's the case, and you understand that, you have to understand when there is a potential for your losing your job, whether it's potential layoffs, terminations, even direct firing or downsizing, you need to make sure that you've retained all the records that are prevalent and important to your employment situation. We've listed those in another video as well. But you need to do that. You need to even be starting to talk with knowledgeable legal counsel in your jurisdiction as to what your rights are as an employee. Because if you take precautionary steps, preliminary steps in advance of this happening, hey, and it might not happen, but at least you started collecting the records for when it does happen. It might only happen in a year, 2 years, 3 years from now. It might happen tomorrow. But if you take these preparatory steps in advance, you won't find yourself in the dilemma of having to try to go back to your former employer now. They're your former boss. They're no longer your boss. And they're going to say, well, have your lawyer talk to us. Have your lawyer talk to our lawyer, and we'll process the whole thing. Why do you want to go through that whole thing? There might be nothing there by way of a case. But at the same time, if there is something there, shouldn't you be in possession of the information and materials needed for you and your lawyer to review that information to make the appropriate determination as to what you're doing? So don't rely upon your former boss once you're terminated to provide you with all the information and materials that you need from the company. Because you might get it, and you're probably not going to get it. And what they can provide you is only what they want to provide you with. And that's how it is. They're going to selectively give you information. But the real information you want, the best way, and oftentimes the only way to get it in a timely fashion, is to have obtained it yourself, given that it is material that is pertinent to yourself, it is personal information, it is not the exclusive property of the company. And that's important to remember. We're not talking about taking proprietary materials. We're talking about materials and information that was specifically designed and meant for your retention and for your records. And on top of that, there's additional information that should be provided by your employer, at least what we see here in the province of Alberta, that needs to also be provided. But even though it's required by law to be provided, employers are so reluctant to provide it because they realize that upon reviewing it by the lawyers for the employer, that this material is exceedingly problematic. And they see where the problem is, and they want to try to push it aside and not necessarily provide it in a timely fashion or without a legal battle. And that is what we are faced with at times. And that is what happens when you don't take advanced action in these matters. So that's why you need to be talking to legal counsel early on. You need to be taking appropriate and legal steps to protect your interests as to your employment information, your employment records, and your position going forward when there are impending layoffs, impending terminations, potential firings on the horizon. You don't want to wait too long because, as we say, once it's done, and the walls come down, and it's very difficult to get the information that you require. Thank you.